Right, so anyway, welcome everybody. It's great to see so many of you have logged on. We've got 100 participants on this webinar, which is one of One Chancery Lane's weekly webinars where different members of chambers are talking about different areas of their expertise, trying to share some of their knowledge, and also trying to help those of you tuning in with some of your caseload. We know how busy you all are. My name is Francesca O'Neill. I'm 2012 call. I'm a junior barrister at One Chancery Lane with a specialist practice in professional and clinical negligence, which includes inquests. My co-host is Dominique Smith, 2016 call. She specialises in similar areas, but as you may have heard before coming to the bar, she has the unique insight of having worked for one of Surrey's senior coroners at Woking County Court. Woking Coroner's Court, sorry. Where the perks of having done so involve sometimes persuading an usher to give her a cup of tea. I unfortunately do not get such perks. Not happy about that. This webinar is going to be split into 4 parts. The first part will be a general introduction and update in respect of the application of Article 2 of the European Convention of Human Rights. I'm going to focus on its application to inquests in particular, and then I'm going to do a short part on the way in which coroners approach their obligations in Article 2 inquests, and especially focusing on the way in which conclusions might safely be left to the jury in jury inquests. I'm then going to hand over to Dominique, who will outline some of the recent guidance from the Chief Coroner following the outbreak of the COVID-19 pandemic. We are then both, hopefully, going to have a short discussion about what we think the impact of that guidance and the pandemic will have on the practicalities of hearing inquests in the coming months. And then, of course, we're happy to answer questions at the end. I am going to try and keep the whole session to an hour maximum, about 50 minutes. If we can. So if you have any questions, you can save them for the end, or you can type them, as I already mentioned, into the question and answer box at the bottom, which will make it easier for me and Dominique to see what questions are arising and then hopefully have a chance to answer most of them. If we do not get round to your question today and now, we'll put our email addresses at the end of the presentation, and so you can always send us an email with a question and we promise to answer as long as it's not too difficult. So I'm going to start with Article 2, what it is, why it applies to inquests, and what the leading case law is on it. And I hope that you will be able to follow that and learn something from it, because it is a complicated area of law. And I say that really the starting point for understanding the legal framework behind all of the jurisprudence relating to Article 2 can probably be best understood by examining the leading UK cases. Of course, there's a lot of European law on this as well. I'll touch on some of it, but I'd like to focus on the UK cases. And the preeminent Supreme Court authority on the application of Article 2 is Raybone and Pennine Care NHS Foundation Trust. I've given you the citation on the PowerPoint. All personal injury and clinical negligence litigators should now be aware of how to bring claims for damages under the Human Rights Act when remedies under other statutes or at common law are unavailable or are insufficient. And I thought I would give you some of the background to Raybone so you can understand why these particular issues arose. In April 2005, Mr. and Mrs. Raybone's 24-year-old daughter, Melanie, was admitted to the Defendant Trust's psychiatric unit at Stepping Hill Hospital. She was suffering from a severe depressive episode and had made a number of suicide attempts. She'd been treated at the unit as an inpatient a month previously. She agreed to her admission, and so she was not detained under the Mental Health Act 1983, but it was recorded that if she tried to abscond, then she should be detained. This is an important point. She was placed on 15-minute observations until a week after her admission, and following a consultant review, she was allowed home on leave. There had not been any psychiatric review between admission and the decision to allow home leave, and that was granted for 2 days, and Melanie was encouraged to see her friends and to, I quote, not talk about herself, end quote. There was no support plan, save that she was put into the care of her parents, who had expressed their opposition to her being allowed home. And very sadly, the following day, Melanie hanged herself from a tree in a local park. Mr. Raybone brought a claim on behalf of his daughter's estate under the Law Reform Miscellaneous Provisions Act 1934, seeking compensation for funeral expenses and Melanie's pre-death pain and suffering. That claim was settled in 2009 without an admission of liability, and the defendant paid the estate the sum of £7,500. A year later, the trust formally admitted that it had been negligent in granting Melanie leave to go home. There are several important judgments in the judgment in Raybone, and Lady Hales is one of them. What she said as she begins her judgment is, well, the hospital trust has admitted liability to her and paid a sum in compensation to her estate. So why, some might ask, are we here? We are here because the ordinary law of tort does not recognise or compensate the anguish suffered by parents who are deprived of their life of their adult child. The claimants were not entitled to the statutory bereavement award under the Fatal Accidents Act, nor were they financially or otherwise dependent on Melanie. Having no other means of redress, they sought recognition for their own loss and suffering by bringing claims under the Human Rights Act. So, what are the relevant provisions of the Human Rights Act and the Strasbourg and domestic jurisprudence relied upon and discussed in Raybone to support a claim for damages under the Human Rights Act? This is essential to understanding the operation and application of Article 2, and by understanding this, you understand why it is that Article 2 inquests have their particular remit. So I promise it is relevant to inquests. In UK law, of course, there is the Human Rights Act 1998, with which we are all familiar. By Section 6.1 of the Human Rights Act, it is unlawful for a public authority to act in a way that is incompatible with a convention right. NHS trusts are public authorities, and the courts have taken a narrow view of what constitutes a core public authority. Under Section 7.1 of the Human Rights Act, a person may bring a claim against a public authority alleging that it has acted unlawfully under Section 6, but only if they are a victim of the unlawful act. By Section 7.7, a person is a victim under the Human Rights Act if they would be a victim for the purposes of Article 34 of the Convention on making an application to the European Court of Human Rights. All that Article 34 says is that the European Court of Human Rights may receive applications from any individual or group of individuals claiming to be the victim of a violation of a convention right. And so the jurisprudence of the European Court of Human Rights is what governs whether an individual is a victim, and that's the reason that you see so many Strasbourg cases cited in Raybone and the other leading UK authorities on bringing claims under the Human Rights Act, who is a victim, and how the obligations of the state under Article 2 apply to them. So, first you must be able to show in any given case that you're instructed in whether you are representing a potential claimant or whether you are representing the public authority, that Article 2 is engaged, and there may well be a significant argument between the parties about that. You'll see why in a moment. But it's important to note that inquests and the coronial law system is a very significant part of the way that the United Kingdom discharges its obligations under Article 2. So Article 2 of the Convention, people talk about the operational duty, but what does Article 2 actually say? It provides that everyone's right to life shall be protected by law, and it's one of the most fundamental rights under the Convention. The European Court of Human Rights has interpreted Article 2 as imposing 3 distinct duties on the state, and I will go through those briefly now. The first is a negative duty to refrain from taking life, save in exceptional circumstances, and you'll possibly recall a case of McCann and the United Kingdom, which was a 1996 case in which the SAS shot dead some IRA suspects on the Rock in Gibraltar. And there was an examination about the taking of life in those circumstances. Of course, quite relevant to what we're considering in the news every day now. The second element is a duty to conduct a proper and open investigation into deaths for which the state might be responsible. So that's sometimes called the investigatory duty. The requirements for satisfaction of the investigatory obligation under Article 2 of the Convention were set out in a case called Jordan and the United Kingdom, and I've given you the citation in the PowerPoint. The obligation under Article 2 includes a duty to ensure that there is an investigation into a death which may be the result of a breach of Article 2, and it should be independent, accessible to the victim's family, carried out reasonably promptly, and provide, insofar as is possible, a sufficient element of public scrutiny and the determination of any Article 2 issues arising. In Jordan, the court said, the authorities must have taken the reasonable steps available to them to secure the evidence concerning the incident. Any deficiency in the investigation which undermines its ability to establish the cause of death or the person or persons responsible will risk falling foul of this standard. That's paragraph 107. Thus, it is the authorities on whom the obligation will rest, and the form that the investigations will take may vary from case to case, but they'll usually include a combination of an inquest, perhaps civil proceedings arising out of the inquest, internal or other investigations or inquiries, and those of you who work for hospital or NHS trusts or other public authorities will be aware of the importance of those root cause analysis reports, the serious incident reviews that are carried out after a death or another serious incident, and those actually are essential in discharging the Article 2 obligation, because they show that the public authority has appreciated the magnitude of what's happened, has conducted its own investigation, and that investigation then feeds into the independent inquisitorial investigation that the coroner will then undertake, of course, where a death is involved. All of this kind of stemmed out of a 2004 case that most of you, again, will be familiar with, that of Middleton. That's where the House of Lords considered the requirements of an inquest into the death of a prisoner in custody imposed by the investigatory duty under Article 2. In Middleton, the court said, the European Court has repeatedly recognised that there are many different ways in which a state may discharge its procedural obligation. An inquest is the means by which the state ordinarily discharges that obligation, save where a criminal prosecution intervenes or a public inquiry is ordered into a major accident, usually involving multiple fatalities. To meet the procedural requirement of Article 2, an inquest ought ordinarily to culminate in an expression, however brief, of the jury's conclusion on the disputed factual issues at the heart of the case. And of course, here's the nub of it. The potential for concealing errors or misconduct by the authorities is all too obvious. In Middleton, that was following a prisoner's suicide, but it could apply to any scenario. So Article 2 imposes an obligation on the state spontaneously to hold an independent investigation to establish the facts and discover whether anything went wrong, and if so, who was responsible, and to learn important lessons for the future. One of the questions asked ahead of this webinar and sent in to us was whether the state can ever argue that not all unnatural deaths in prisons engage Article 2. And I would say that following Middleton and following Raybone, where the class of those deaths which do attract Article 2 engagement can apply even without formal state detention, so you don't need to be a prisoner, I would say that the class of cases in which it could be successfully argued that Article 2 doesn't apply would be very small. I would never say never, because each of these cases is very fact specific, but I would say that it would be difficult to imagine the circumstances in which you would successfully argue that Article 2 had no relevance at all. Of course, sometimes you have an Article 2 inquest and it turns out that actually, although it might appear as though Article 2 is engaged, actually it's not. And, you know, I've certainly handled Article 2 inquests where that has been the case. So just because it's an Article 2 inquest, it doesn't mean that Article 2 is engaged. That's part of the purpose of the investigation. And then coming on to the third element of the operational duty, and this is perhaps the controversial aspect which was really discussed in Raybone. There's a positive duty to protect life in certain circumstances. This positive duty has two elements. First, there's a duty on the state to put in place a legislative and administrative framework designed to provide effective deterrence against threats to life. And second, there's an operational duty to take steps in certain well-defined circumstances to safeguard the lives of particular individuals. And of course, I've given you the citation there for Savage and the South Essex Partnership, where that was a particular area of discussion. So whilst the focus in Raybone was on this operational duty, when and how it applies, practitioners must not forget the importance of the general protective obligation. So hospital trusts, prisons and local authorities should have in place policies and procedures to protect the lives of patients, inmates and care home residents. Again, I mentioned care home residents because I think we're going to see a certain amount of scrutiny in the coming months about how COVID-19 and in particular the terrible effect it's had in care homes, whether that engages Article 2, I suspect it does, and whether there may be inquests, inquiries, or even a public inquiry into that particular area. So just flagging that up. In relation to the operational obligation to identified individuals, the starting point was a 2000 case. Again, you may well be familiar with it, Osman and the United Kingdom. That was a very sad case where the Osman family had been subject to threats and harassment from their son's teacher, who had developed an unhealthy obsession with his student and who later murdered Mr. Osman and wounded the boy. The family's case was that the police should have taken steps to protect them from a known and serious threat to their lives. And the court held that an operational duty to protect an individual arose where the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers, which, judged reasonably, might have been expected to avoid that risk. And in subsequent decisions of the European Court of Human Rights, the operational duty has been held to arise in much wider circumstances, for example, in relation to the protection of prisoners from harm from others, prisoners at risk of suicide, immigrants in administrative detention, army conscripts at risk of suicide, psychiatric patients detained in a public hospital under the Mental Health Act 1983 at risk of suicide, and of course, as I talked about in Raybone, this was a very sad suicide of somebody who was not actually detained in hospital. And so it goes wider than that. The Osman formulation with slight variation is often recited by the European Court of Human Rights in its decisions on Article 2 cases. The operational duty arises in well-defined circumstances, but actually the Strasbourg court has defied any attempt to describe clearly what those circumstances are. But luckily for us, Lord Dyson's judgment in Raybone referred to certain indicia which point the way. The first is that the operational duty will be held to exist where there's been an assumption of responsibility by the state for the individual's welfare and safety, including by the exercise of control. So you can see that applied in the specific circumstances of Raybone, because although Melanie was not under formal detention, the hospital had assumed, it was found that the hospital had assumed responsibility for her welfare. Second, in circumstances of particular vulnerability, the duty may exist even where there has been no assumption of control by the state, such as where a local authority fails to exercise powers to protect a child. And the third factor is the nature of the risk. An ordinary risk of the kind that individuals in the relevant category should reasonably be expected to take will not give rise to a breach of the obligation. An exceptional risk may do so. Now, one of the questions that was sent in ahead of this webinar was whether Article 2 is ever engaged in sort of, I don't want to say run-of-the-mill, but in a standard clinical negligence case where there's a question of clinical error in a normal physical hospital, not just in the particular circumstances of psychiatric admissions. So, you know, a broken leg, an operation gone wrong. And I think that third factor is very relevant to that, because when somebody undergoes surgery in hospital, there are ordinary risks of the kind that individuals in the relevant category, so the category of people undergoing that particular surgery, are reasonably expected to take, and that would not necessarily give rise to a breach of the obligation. But if things went exceptionally wrong, kind of akin to what we might think of as gross negligence, then there is a possibility that the operational duty would be engaged even in a hospital setting. Focusing particularly, of course, on inquests, an important consequence of the Middleton and then Raybone decisions is that the requirement for coroners to hold Middleton-style Article 2 inquests, so where there are grounds to suspect that state agents may have breached obligations under Article 2, that will now arise in a wider range of cases. And in fact, of course, because Middleton was a 2004 case and Raybone was a 2012 case, that has been the case in the last few years. There's a separate question about the granting of public funding in a wider range of inquests, perhaps a topic for another seminar. But I think it's clearly the case that we've seen enhanced Article 2 inquests held in suicide cases, where a psychiatric patient, whether detained or not, might have been known by the authorities to be at a real and immediate risk of suicide. We were asked another question ahead of the webinar, which was how easy is it to secure an Article 2 inquest in mental health triage cases? So, for example, when someone presents at A&E with a suicidal ideation, but is then discharged, and what are the best ways to approach this argument? And my thinking about that is that, of course, as ever, it will depend on the particular circumstances, but I hope that by understanding the implications of Raybone and Middleton, it will usually be quite easy to persuade a coroner that there is a possibility that the operational duty under Article 2 has been engaged and or breached, and that that's a factor which will require exploration at the inquest. So I don't think that the hurdle is persuading a coroner that Article 2 may apply. The hurdle will be during the course of the inquest, after and during the evidence is being heard, making the relevant submissions on whether or not that duty is in fact engaged and whether in fact it has been breached. And that's why I've spent such a long time today talking about these leading cases, because it is a complicated area of jurisprudence, but coroners are very familiar with it. And you have to be able to look at the European jurisprudence and not be scared by it in order to make appropriate submissions on behalf of your client, whether that is the family of the deceased or whether you are representing the public authority. So, an example of that is I've just been asked recently to advise an NHS trust on a claim made under the Human Rights Act, which emanated from a Article 2 inquest that I represented the trust in last year. And the claim is brought under all of these quite complicated potential causes of action. So it's asserting breaches of Article 2 and of Article 8 of the Human Rights Act, Article 6 of the Human Rights Act, and it's asserting that a sibling had been a carer and was a victim entitled to damages following Raybone. And, just briefly, you mustn't be afraid to dig into the jurisprudence of the European Court of Human Rights in search of answers when confronted with sometimes quite complicated legal scenarios and often based on quite distressing factual scenarios. Obviously, families, professionals dealing with quite personally tragic circumstances. So I'm just going to move on briefly now to the way in which Article 2 is handled in practice during the course of inquests sitting with a jury. I'll be looking at the obligations of the coroner in relation to the approach taken first in relation to funneling the factual evidence obtained during the course of the inquest into a potential set of conclusions, and then how the coroner determines what conclusion or conclusions are safely left to the jury. So the coroner, as we all know, is under a duty to ensure that the jury answers the 4 questions set out at Section 5 of the Coroners and Justice Act 2009. So who the deceased was, when they died, where and how. And in an inquest engaging the procedural duty pursuant to Article 2, the how question is to be interpreted as including in what circumstances. Identifying the issues to determine the how question is a 2-stage process. Firstly, a funneling exercise must take place whereby the central issues to the death are distilled from all of the evidence heard in the course of the inquest. And secondly, the coroner must then be satisfied that those relevant central matters meet the Galbraith plus test. Matters investigated within the broad scope of an Article 2 investigation often do not form part of the ultimate conclusion. So this goes back to what I was saying before. Often it's quite easy to persuade a coroner that Article 2 may be relevant, but just because it's an Article 2 inquest doesn't mean that the evidence will support that. So the process by which a broad Article 2 complaint inquest distills the relevant evidence going to the central issues from the wider investigation. Even in an Article 2 inquest, although the ambit of the evidence heard may be wide, a conclusion may only lawfully encompass causative factors. If it cannot be said at the end of the inquiry that there is a realistic causal connection between certain factual matters and the death, including potential state failures, then it is not permissible to return a conclusion encompassing those matters. If a coroner is of the view that there is evidence that there is a fact or a circumstance which could have caused or materially contributed to the death, but cannot probably be shown to have done so, then the court has a power but not a duty to include it in a narrative conclusion. However, that must constitute a real possibility, and matters that are no more than speculative should not be included. Quickly then, the evidence required for a matter to be left to the jury, as set out in the Chief Coroner's Law Sheet number 2, entitled Galbraith Plus, in deciding whether or not to leave a particular conclusion to the jury, the coroner must make a judgment based on sufficiency of evidence. As all coroners will now be aware, they must first be satisfied that there is sufficient evidence upon which a jury properly directed could properly reach a particular conclusion. And then even if that is the case, the coroner must then also be satisfied that it is safe to leave the conclusion to the jury. As to what is meant by safe, the Chief Coroner's Law Sheet number 2 at paragraph 10 draws attention to the dicta of Lord Wolfe, the Master of the Rolls, or then the Master of the Rolls, in a case which is R. Regina and Inner South London Coroner ex parte Douglas Williams, a 1999 case. And what Lord Wolfe said was, I think I've set it out, but if it appears that there are circumstances which in a particular situation mean in the judgment of the coroner acting reasonably and fairly, it is not in the interest of justice that a particular verdict should be left to the jury, he need not leave that verdict. Therefore, it's settled law that a coroner may not lawfully leave a particular conclusion or finding to a jury if there's either insufficient evidence upon which a jury properly directed could properly reach such a conclusion, a matter of judgment, or if the evidence is, for example, so inherently weak, vague, or inconsistent with other evidence, it would not be safe for the jury to come to that conclusion, and that's a discretion. Sorry, that's been a slight whirlwind. I'm conscious of the time. I'm now going to hand over to Dominique, who will tell you all about the latest guidance from the Chief Coroner as regards the COVID-19 pandemic and the way that it has in particular affected the hearing of all inquests, but particularly Article 2 inquests in the last few weeks and perhaps what we might expect in the coming months. So I'm going to hand over to you now, Dominique.
Thanks, Fran. So as many of you know, as a result of the pandemic, the Chief Coroner issued a number of pieces of guidance to help coroners really navigate through this period. And the main piece of guidance that you should all be aware of is guidance number 34. And it is emphasised within that document that it is to be the main piece of guidance. Now, the current position remains that there should be no physical hearing, so no physical inquest or pre-inquest review, unless it's deemed to be urgent and essential business. However, if an inquest or a pre-inquest review can take place remotely, then it should do so. The difficulty is that coroners need to be physically present in a court building, so they can't conduct hearings from their home. And essentially a coroner's court is not a coroner's court without the coroner physically being there. So if a coroner is dealing with a matter and the question arises as to whether it should be held or heard remotely, that's entirely within their discretion. A coroner may feel that due to the number of witnesses or interested persons, it simply isn't feasible to hear the inquest or pre-inquest review virtually, but that is of course a matter for them. But there may also be situations where you have a number of healthcare professionals attending, for example, and they have to give evidence, but it may be that they cannot physically attend or even attend a remote hearing because they're working on the front line during the pandemic at the moment. The guidance does stress that coroners should recognise their primary clinical commitments, and including those of pathologists as well. It's inevitably going to result in a number of reports and witness statements that are essential for an inquest to take longer to obtain than usual. Naturally, it seems as though we're all going to have inquests adjourned for a number of months, and the guidance note 3 had said that essentially the inquests with a jury, for example, would be adjourned until the 28th of August. And if we have a second wave of the pandemic, I can only see that they'll be adjourned further. So it really depends on when social distancing is lifted and how really we get out of this first peak of the virus, and if there is indeed a second peak. The guidance also touches upon prevention of future death reports. Now, of course, some of you may have had inquests just prior to the lockdown and the pandemic really hitting the UK, where a prevention of future death report was made in respect of a trust, for example, or a healthcare professional. And a coroner can give, according to the guidance, an extension of time for a response if a response is due and it hasn't been provided yet. But there is a big but here. There is no blanket policy of extensions for prevention of future death reports, so you can't guarantee that you will get one. Certainly, if you think that more time is needed for your response, of course, you can write to the coroner for an extension. I would have thought that the coroner would have reviewed their responses and indeed written to the individual, to the organisation or authority involved to say that an extension will be granted. But if you haven't heard anything, of course, do write to the coroner for an extension. One of the biggest things to take away from Guidance Note 34 is that COVID-19 is essentially a natural cause of death. So a death from COVID-19 in itself is not a reason to refer the death to a coroner. But there are going to naturally be some cases where it will be necessary to report a death to the coroner if the cause, for example, isn't clear, or if there are factors that have contributed to the death that need to be explored. But a death from COVID-19 on its own is unlikely to warrant an inquest. The guidance also discusses post-mortems, and as we all know from the government's daily briefings, the daily death rate at the moment is still high, and pathologists therefore may not be actually able to conduct a post-mortem. But also there may be an infection risk, which means it's not possible to carry out the post-mortem at all. And coroners have to simply take a pragmatic approach to this. There may be circumstances where they can't be sure that a death has been caused by COVID-19, and there may be other considerations that lead to the view that the cause of death is unknown. And if a death is a suspected COVID death, but it can't be established satisfactorily, and a post-mortem can't be arranged in a reasonable time, the matter may have to proceed to an inquest. In respect of Guidance 35, that's a particularly short piece of guidance, which I won't trouble you too much with. Essentially, it attempts to deal with some of the questions being asked about virtual pre-inquest reviews and inquests. Now, as we know, of course, it's entirely within the discretion of the coroner if the coroner believes that the inquest or pre-inquest review can be held by remote means. But naturally, some questions have been raised as to why an inquest or pre-inquest review can't always happen remotely, but civil cases, for example, are being heard. And the guidance essentially stresses that coroners don't have the flexibility under the coroner's rules that judges have in civil proceedings under the civil procedure rules. And that's really because a coroner has to be physically present in the courtroom. The difficulty is, even if you have an inquest or pre-inquest review that could take place remotely, the difficulty may arise if a coroner themselves falls into the category of someone being a vulnerable person because of an ongoing health condition or because of age and the like. And that may mean that it's not safe for them to travel to court to conduct the hearing, and subsequently, again, an inquest may need to be adjourned. Guidance number 36, again, is relatively short It largely deals with the medical certificate of cause of death, so MCCDs, and remote verification of death, which most of you won't need to trouble yourself too much with. But one thing that it does stress, of course, is Section 30 of the Coronavirus Act 2020, which I've popped on the slide for you, which essentially removes the requirement for an inquest to be held if the coroner has a reason to suspect that the death was caused by COVID-19. Now, there was a question raised prior to the webinar which asked, with remote verification of deaths now possible, does a coroner have any jurisdiction to object to this? And some of you may or may not be aware that the senior coroners of London have already issued a statement objecting in part to the remote verification of deaths procedure. And their statement in essence says that they are aware that GPs have been informed that absolutely anyone can verify a death and that there's no need for any special training to do so. And other organisations have told their GP members that essentially verification of death can be carried out by any suitably qualified person. But they also include the fact that verification of death could be carried out by a funeral director, for example, or a family member. Senior coroners of London have said that this view doesn't actually reflect professional practice. So in essence, they have said that although they agree that verification of death should be undertaken by a suitably trained healthcare professional, so someone who's undergone some training, for example, a doctor, a nurse or a paramedic, or indeed there may be some specific circumstances where a police officer could verify death. They make plain in no uncertain terms that they do not consider it to be acceptable for an untrained funeral director or a family member to verify life extinct. Now, you may wonder why that may be the case with a funeral director, for example, because surely they deal with the deceased on a daily basis. But this is the view of the senior coroners of London. So to come back to the question, it seems as though, from my perspective, a coroner could have jurisdiction to object to it if they feel the individual who verified the death isn't actually suitably trained to have recognised death. And they've also stressed within their statement that actually they have reservations about general practitioners telling family members down the telephone what checks to carry out to see if life is extinct. Now, interestingly, this is, of course, the senior coroners in London's view, but not all coroners are taking the same approach. So I understand, I believe it's in Leicestershire, that the coroners there don't have any issue with a GP telling a family member over the phone how to verify life is extinct as they guide them through the process. So it's worth having a look at the approach that the coroners in your area are taking. I thought then to come on to guidance number 37, and it's one that's really got more of a personal injury aspect to it rather than a clinical negligence aspect, but I thought I would touch on it briefly in any event. So as we know, if the death is by COVID-19, it's likely to be a natural cause of death, but it may be unnatural if it's caused by a naturally occurring disease, so COVID, but there is some human error that has contributed to the death. And the guidance note specifically deals with deaths and exposure to COVID in the workplace. So this is really touching upon issues of PPE, which has been a real hot topic in the news during the course of the pandemic, and indeed the inadequacy of either supply or the actual PPE itself. But the guidance has really stressed, and it's Chief Coroner stressing this, that an inquest is not the right forum for addressing concerns about government or public policy, nor is it the right forum to decide whether adequate arrangements were in place with respect to PPE. What the guidance doesn't do, however, is say that coroners cannot consider PPE at all. So I do think, and there were some questions about this before, that whether the scope of the inquest could cover PPE at all. Now, it seems to be, from my view, the guidance doesn't prohibit PPE from being discussed, and equally, coroners can't absolve themselves from their Article 2 investigative duties. So I do think that it can fall within the scope. But what the Chief Coroner seems to be suggesting is that actually the appropriate forum for this and to really be discussed would be in a public inquiry. Well, what's the issue with that? essentially we haven't heard if a public inquiry is going to take place. So it is quite an unhappy situation. And what I suspect will happen in the coming weeks is, or indeed in the coming months, is that there may be some judicial reviews that take place because a coroner has decided on the basis of the guidance that they're not going to deal with PPE because it says it's not the right forum. But ultimately, it doesn't say, the guidance is guidance, and it doesn't say they cannot deal with this at all. So it may be appropriate in some cases for the Article 2 duty to be discharged effectively is for a coroner to deal with that within the scope of the inquest. I doubt, however, that coroners will really want to deal with it by the nature of what the chief coroner said. We know that they generally tend to follow this guidance by the letter, really. So what do we think the impact is of the pandemic on inquests? Well, Fran, I'd be interested to hear your views on this as well, but it seems as though I think there are going to be a number of judicial reviews, particularly around this PPE point and the scope of inquests and whether they've been unnecessarily curtailed. But also we're going to just have a real backlog of cases and a number of adjournments. Fran, what do you think?
Well, no, I mean, I think what we've all seen over the last few weeks, and not just in inquests, but definitely in inquests, is just wide-scale adjournments of hearings. So certainly inquests, I think we've both had inquests which we were supposed to be representing parties at, which have been adjourned, and not just adjourned for a while. The backlog is such that we might now see very serious delays, I think, to the hearing of particularly Article 2 inquests lasting more than 1 or 2 days, and of course those involving juries. Of course, some of those inquests are heard in buildings which are criminal courts, and so I was thinking that particularly in those it may be possible to hear an inquest with a jury where social distancing was imposed because the jury was able to sit in a separate room, as has been suggested for criminal cases. But I also think that it's unlikely for inquests in general to take precedence over the backlog of criminal cases that will also be waiting to be heard. So yes, I think the reality is we're all going to have to face up to the fact that there are going to be significant delays. And of course, that's really very difficult if you are representing a bereaved family, to tell them that the investigation into their loved one's death is not going to now be dealt with for months or even into 2021. And likewise, it makes it harder for public authorities. I'm thinking of hospital trusts, police forces, where the memories of the witnesses who dealt with the sadly dead person will not be as fresh. And I can foresee that leading to a real need now, where you think there may well be an inquest, to make sure that people have taken notes and are, have in the back of their minds that they may be required to give evidence at a future point, and it may not be as soon as we're used to. So so I think that's definitely the case. I've been dealing with some of the questions in the question and answer section, Dominique. There was a question about this from Arfan Bhatti, who was asking about what happens in a case where you would normally refer it to a coroner, but there's already been a death certificate saying that it was a COVID-19 death, and it could of course be post-burial as well, and that's quite an unusual circumstance. And what I said is, I think, my impression is that where there are big questions like that, which are going to apply to very many deaths, it's quite likely that will form part of the substantive inquiry of any future public inquiry into this. So I wouldn't kind of prejudge the situation. I would wait to see whether there is specific guidance that's going to be issued on this, or whether it's going to be dealt with in a public inquiry. But I also think that if that guidance isn't forthcoming, or there is an inquiry which doesn't deal with this, but you've got a COVID-19 death, post-death certificate, post-burial, but you think that there are, serious problems potentially with end-of-life care, lack of capacity, lack of PPE at work, lack of track and trace, resulting in 3 deaths in a family unit, these are the examples that Arfan has given, and you refer it to a coroner who then refuses to deal with it, I think that might well form the grounds of a judicial review. So the answer is we don't know, but I think we will find out.
Definitely. I've just seen, I think, another question's come through, which says, where you have a healthcare professional that's passed away during the COVID crisis and it's confirmed this was due to contracting the virus, do you think this may lead the coroner to open an inquest or investigate as to whether there was a failure to appropriately ensure reasonable safety of the healthcare professionals?
Yeah, I mean, I think it's going to be a huge question. We've all seen the tragic news about doctors and NHS workers on the front line suffering from this terrible disease and dying. And of course, it's not just healthcare professionals, but there's also that terrible case of the station worker at Victoria Station who was spat at, and there's an open question as to whether or not she then contracted the virus and died because of that incident. So again, I think the answer is we don't know yet, but I would be very surprised if there wasn't a vehicle for a full investigation into the circumstances of that, whether that would be an individual inquest into the particular death, a wider public inquiry, a wider kind of guidance. We don't know. It's definitely something that is going to arise. Those questions are already arising. They're already being asked. So it's really an open question as to whether or not we are going to we're going to have to wait and see how we deal with all of that.
Absolutely.
And I think that goes, I don't know what you think, Dominique, I think that goes to the question of PPE as well, sufficient PPE, but very similar issues are going to be engaged in, for example, the failure or the potential failure. I think we all hope that it will be a huge success, but the potential failure of the track and trace system.
Absolutely.
How is that going to, is there going to be a causative link? Is there going to be a causative link between the failure of that system and, potentially avoidable deaths? It's really, hot off the press, as it were, these kinds of questions. But they're definitely ones that we have to think about, and we have to think about them against the backdrop of that jurisprudence that we were looking at earlier in this webinar, because really that sets down the way that the English courts are going to approach these difficult and, really traumatic questions, which are going to be so greatly exacerbated by this pandemic.
I think one of my biggest concerns is that I think there'll be a tendency for coroners to read the guidance notes from the chief coroner and just apply them quite literally and guidance quite literally. So I think they will probably restrict scope unnecessarily of an inquest, particularly when it comes upon points touching upon PPE and the like.
Yeah,
we're going to have real issues with a number of judicial reviews. I can't see, as I've read online some comments on Twitter, for example, of some coroners already making decisions that they're just not dealing with PPE at all. No. But whether that really complies with their Article 2 duty.
Well, I think they are probably in a similar position to us, where they think, oh, well, this is such a huge question, it will have to be dealt with properly.
Point, but how and when?
by a central authority at some point. But, we're all kind of waiting slightly. I think the same kind of thing will apply in situations where, under normal circumstances, a family might be considering, well, was there clinical negligence here? And I think from our discussions, certainly I would have expected central government to be thinking pretty quickly about whether it was going to introduce some kind of legislative protection from hospitals that have, undoubtedly been under unprecedented pressure to deal with a huge influx of seriously unwell patients. But so far, nothing. So...
I was going to say, Fran, we promised 50 minutes. And
oh, yeah, we did. I think we've dealt with all of the questions that were sent in ahead, all of the ones that have been asked in the question and answer box. We really hope that you have enjoyed, not sure if that's the right word, but certainly learnt something from this webinar. Our email addresses are up if you've got any follow-on questions or if you want any more information about what we can do to assist. The last thing is there will be there will be another webinar next Thursday.
Well, hey.
And I think it's going to be the second part of a webinar on employers' liability with Andrew Spencer.
Yes, and Ben Hicks. Touched
and so I hope you're all exceptionally, well, as excited about that as we are. But we wish you all a very good day and a very good week, and please do get in touch with us if you think we can help you with anything. But otherwise, thank you very much to Dominique. Thank you all very much for tuning in, and we are going to, I think, shut the Zoom down.
Yeah, I'm just answering one quick question about the slides. If you want the slides, our email address is there. Just drop us an email. We'll email them straight to you.
Yeah.
Hope that helps.
Yeah.
Thank you so much, everyone. It's a pleasure.
Bye.